Paul, welcome back. We're on another live stream here. We've got a fun one today. We're going to be running through a case study. And so I'm excited about it. I'm interested to hear your input on some different things and stuff like that. And so we've already got people joining us here. I think Larry he's on. And so he said, hey, Jacob and Paul, look forward to the conversation today. So Larry, thanks for being here. Glad to have you.
Yeah, I'm not comfortable on a live stream unless Larry's involved and present. So it's great to have you. I think both of us have been excited about this live stream. For the main reason is just we're on YouTube here, and you see a lot of video content in YouTube about pure retirement planning. You see a lot of content on YouTube about pure estate planning. You really don't see any about how they work together and how the financial services industry and the estate planning legal services industry, how they can work together to really make sure clients win. So I'm tickled to death. Jacob and I have hooked up a few weeks ago. I think we share a similar mindset in that we're passionate about the educational kind of aspect of providing good value. So yeah, excited for today.
Yeah. So why don't we go ahead and get started? I've got a scenario for you. I want to pick your brain a little bit. So I'm going to put this up. That way our watchers and viewers can kind of see what we're doing here. But we've got John and Jane. And so they're 65 years old. They just retired. They've got 3 kids that are adults. One of them is happily married. One of them has been married, but's divorced now. And then one of them is unmarried and not the best with money, they mentioned. So we're going to talk through that maybe in just a little bit and how that factors into the estate planning piece. They also have 2 grandchildren, maybe more on the way one day. We'll see. But in terms of assets, they have around $5 million total, and that's made up of around $2 million in traditional IRAs, which is tax deferred, and they have about $2 million in brokerage accounts, and then also $300,000 in cash and an $800,000 house, which is paid for. So that's kind of their facts of who they are. Just a quick overview. Now, what are the things that they mentioned to me that were important to them? What do they want to accomplish, or what were their goals or wishes and things they wanted to do? Well, for them, they've got a decent nest egg there. So they got $4.5 million of liquid money to retire on. And so for them, that's more than enough. They mentioned, hey, we've got plenty of money, we feel like, and we're not big spenders. And so we just want to live and enjoy life. We're not extravagant in any capacity. So for us, we want to enjoy life, but we also want to leave money for our kids and grandkids one day. So they mentioned they wanted to leave about 25% of what was left to the grandkids, and then the rest, the 75% that's left over, equally distributed between the 3 kids. So they want to leave about $4 million total. Now, one of the big questions for them was, what happens if one of our kids get divorced? How does that work in terms of estate planning? And, does the spouse get to leave with half of what we left our kid or not? And then also, what about the one who's not very good with money yet? So we need to figure out a plan for them. We don't want to leave them out, but we want to make sure that they're responsible. So they also, Paul, they mentioned a big one here. They want to avoid probate. They're like, hey, Jacob, we've heard about this probate thing. Not sure what it means, but how do we avoid it? We just heard we need to avoid it. So I want to hear your input on that. And then also tax strategies. And so how do we reduce taxes now while we're living and in retirement, but also how do we reduce them post-death for our kids and our grandkids? So, Paul, that's the situation. I want to hear first from you on probate. What is probate, and why does that matter here to this discussion?
Yeah. So great question. Just a really typical scenario that we deal with. And by the way, hey, Ann, hey, Ray, hey, SW, good to have you here. I want all of you who are watching or who are watching it live, feel free to contribute in the chat. You can ask questions, keep it positive, share experiences that you've had. Really just would love to see some feedback from you. So feel free to grab your fingers and throw some good stuff into the chat. So, like I said, I'm really looking forward. I want to kind of grill Jacob a little bit about the investment and retirement piece, but you did bring up the probate. Usually what happens, Jacob, is, this couple's about 65. A lot of those 65-year-olds who come to me, they're like, Paul, my dad passed away, and I don't know why it took so long, or the lawyer did this, or the lawyer didn't do that, or one of my siblings wouldn't sign off on all the different layers of court paperwork that needed to be signed off, and we had to get all these court orders, but before we could go to dad's bank or his brokerage firm. And it just, it seemed like a hassle. And so what can we do to avoid it? So the short version there is yes, when people pass away with certain assets in their name, and I emphasize certain assets because just like John and Jane here, they have an IRA, and IRAs are left to designated beneficiaries. And so an IRA, like John and Jane have, or probably John has it, is what we call a non-probate asset. The IRA, it's going to be payable to the designated beneficiaries. We'll talk later in this live stream about who are the appropriate beneficiaries of John or John and Jane's IRAs. But that's a non-probate asset. But John and Jane own a house, they own a brokerage account, and depending upon how all that is titled, it's likely that when they pass away, certain assets that they have will be frozen. Now the family's got to come back to lawyers like me. We've got to prepare a bunch of court documents. We've got to get judges and other lawyers involved. And it's just the way it is. This probate process, it was determined a long time ago that the court system, our judicial system, is supposed to be in charge of making sure someone's assets are passed along to the people that they're supposed to be passed along to. But because the judicial system does oversee that, it's cumbersome, there's delay, there's hassle. And so a lot of people love the idea of arranging what they have to avoid probate. We'll not only talk about that, I'm going to show you some of the mechanisms that are involved in avoiding probate, but that's what it's all about. It's trying to make things easy for your spouse, easy for your children, so they don't have to go through a bunch of legal red tape just to inherit a bank account or some shares of stock or a business that someone has when they pass away.
Yeah. So how long on average does a probate last? I'm curious.
Yeah, you would ask me that question. And so it's a really tough question. Of course, the lawyer answer is going to be, it depends. It depends on who's involved and whether they're cooperative, and is the attorney on the ball, and how long does it take certain layers of paperwork to go through the court system and the clerk of court, and how long does it take for judges to sign orders, and then once those orders are submitted to financial institutions, how long does it take those institutions to approve distributions of assets, or all of the heirs cooperative, because all of the heirs have to sign off on these levels of paperwork. So if you have one uncooperative heir, it typically goes from months to years. But if I can answer your just how long does it take question, I'm going to answer it with it takes months.
Okay.
And in some cases it kind of bleeds into years, all depending upon the circumstances.
Gotcha. Yeah. I see those types of things, or the probate process, play out in clients whenever they have a parent or someone pass away. It's like, hey, Jacob, I'm going to receive some money, but I'm not sure when. And so it's like, well, how was it, arranged? It sounds like it was through probate, going to go through probate if that's the case. And so these are the things we're trying to help educate on so that we can avoid them if at all possible, because it does delay things. It costs money, and your assets are often frozen. I think we mentioned that last time, whenever they're going through probate as well. So just really depends.
Yeah, and look, on the other hand, not every probate is a complete disaster to the family. I've been involved in many probates where maybe dad died and he owned a home and a bank account and a vehicle and had two children, and maybe the two children were like, we get along, we'll work with a lawyer, we'll sign whatever we need to sign. We're not in a hurry to inherit the assets. We do well. We have our own assets. If it takes 4 months, if it takes 6 months, so be it. They'll go through probate, and it doesn't necessarily have to be an unpleasant experience. But I still say most people want to make it. It's kind of the last thing you can do for your family. You've worked your entire life. This is something that involves your closest loved ones. Most people like the idea of just making it as easy as they can for their survivors. And when you can't avoid probate, it does simplify things.
Awesome. Okay. Wonderful. Good input. In terms of their kids and their grandkids, curious, they've got one kid who's, hey, not super financially responsible yet. Well, hopefully we'll get there one day. One has been married and then now is divorced, but also we have another one who is happily married and has a couple kids. And so, in terms of leaving assets one day, that is one of their wishes and goals. They want to leave, millions of dollars to their kids and grandkids. there's a lot of complexity built into that. And so I'm curious, I'm just going to throw a big question at you. How do they do that really well?
Another tough question. Jacob, you got to give me some softballs, but no, that's a tough question. In this case, John and Jane had 3 kids. One was kind of the ideal child, married, responsible. One's been divorced, and one just can't handle money. So it's a tough one for parents, because parents have that dynamic of, do we want to treat our children equally? Not even so much, it's pretty obvious they want to leave, 1/3 to each child. But even within that discussion, do we really want to say it's okay for this mature, responsible child to get their 1/3, but we want to restrict this other child from being able to access all of their inheritance? So there's that dynamic involved for parents. Do we want to really treat them the same across the board, or are we okay because perhaps in this particular child, it's in their best interest that their inheritance gets doled out to them over time? So that's a dynamic that we have to talk through. But to address these 3 situations, I would say they've had a child who's been divorced. So that's probably a concern of theirs. It was probably a difficult situation for not only the child to go through, but also the child's parents, John and Jane, to go through. So there's this divorce proof component to it. And I'm going to try to keep this short. So what I suspect what John and Jane will like, and of course we don't know if they'll like it until we ask them, but John and Jane probably like this aspect of making their children's inheritance divorce proof. And so how do you do that? Well, typically what you don't do is just in John and Jane's estate documents, which I'll show you in a little bit here, John and Jane could just leave everything 1/3 each to the children. But when parents leave assets, what I call outright to the children, there's a chance that those inherited assets may get commingled with other assets they have with a spouse. And then when the child gets married, they perhaps lose half of their inheritance. So a lot of parents like the idea, let's say Sally's been divorced, of leaving Sally's part to the Sally Trust. And maybe Sally's responsible, she's mature. Name Sally as the trustee of the Sally Trust. But when John and Jane die, Sally's 1/3 doesn't just go directly into Sally's name. It goes into Sally as trustee of the Sally Trust. And by leaving it to a trust, at least John and Jane are setting it up. So it's really kind of hard for Sally to commingle those trust assets, because they'll be titled at your office, Jacob, in accounts titled Sally as trustee of the Sally Trust. Kind of hard for Sally to commingle those assets as long as they stay in that trust. If Sally gets divorced, she keeps her trust. Sally splits the other assets that Sally has with her spouse. So that's often how we handle the divorce proof issue. And most parents say, look, we love our son-in-law that our oldest daughter is married to, but let's, but you never know what's going to happen. So let's just do it that way for all of our children. Now, the concern and the deep discussion goes, what about this child who can't handle money? And so then, dad said something like, geez, when I would give that child a nickel, he would spend a quarter. There's no way I'm going to leave him $1 million. And so now that those parents have a decision to make, do we carve out? Yes, you're going to, and let's say that child's name is Jason. Do you set up Jason's trust so that when John and Jane die, Jason's not the trustee. Somebody else is the trustee. Could be an individual, could be one of the other children, depending upon the relationship. Yeah. Sometimes you don't want to put a responsible child in charge of an irresponsible child's inheritance, because the irresponsible child is going to be badgering that responsible child to give them some of their inheritance. Maybe it could be a corporate trust company that could serve as the trustee for the irresponsible child's part. And now, there'd be a deep discussion about at what points, when should distributions be made after John and Jane pass away for this child, so that child can really benefit from the inheritance for the rest of that child's lifetime. So, and
all those stipulations can be built into that trust for the irresponsible child, right? Like, hey, you can only pull so much, and you can pull for these reasons, right?
Yeah, it sure can. In fact, I'm gonna show you that in a minute, okay. But now I'm gonna turn it back over to you, Jacob, because I want to hear. We haven't talked about this. I want to hear what your thoughts are about the appropriate kind of investment philosophy, retirement income planning.
Yeah.
And then I'm going to show you some stuff, and then we'll merge the financial and estate stuff together.
For sure. Yeah. So one of the details here on John and Jane was that they've got $2 million in IRAs, but also $2 million in brokerage accounts. Now, the key on the brokerage accounts is that 1 million of that 2 million is actually their basis. So they've got $1 million of growth that's happened in that brokerage account. So that's taxable at a long-term capital gain rate. Now, when they're in retirement, they can pull at least a portion of that, depending on their income, at a 0% long-term capital gain rate. And we can control their income. They'll have some Social Security and other things. But outside of that, they won't have any other taxable income outside of their Social Security at this point because they don't have any pensions. So one of the things that we can think about is, hey, they want to leave money to their kids. They have to have something to live on as well on top of their Social Security. Again, they're not extravagant, so they don't need $300,000 a year from these accounts. But which accounts do we pull from? That's a question that goes through my mind. Hey, where do we pull money from and why? So some things that I always think about in a retirement plan is going to be Roth conversions if we have large tax deferred accounts. So that's maybe a question here we want to answer. But also we've got the potential to have tax-free capital gains on the brokerage account if we want to pull money from there and do that at a tax-free way. But the key is we've got $1 million of growth. So whenever we want to leave money to the kids, something that's in my mind is that step up in basis. And I might, pick your brain here a little bit and explain a little bit to the listener on what that is. But if we want to leave that money to them, would it be wise to, pull money out of the traditional IRAs and live on in retirement and dwindle that down? Because there's another point in a second I want to make on that in terms of RMDs. But the brokerage account is there. We can pull on that tax-free now, but it could make a larger tax liability for the kids and for us if, John and Jane living in RMD age later. So that step up in basis, real quick, I want to have an aside for you. What is that and why is that crucial kind of for what we're looking at here?
Boy, people love the step up in basis, as well they should. It seems to be this big tax break that exists and maybe one of the best and only real tax breaks that exist. So let me give you an example. Let's say maybe Jacob, one of your clients bought some Apple stock, for $100,000, and now that Apple stock is worth $200,000. In fact, in our example, as you mentioned, Jacob, generally speaking, it's a $2 million brokerage account. And in that $2 million brokerage account, the fair market value of the investments is $2 million, but the cost or the acquisition cost of, what those John and Jane purchased those investments for totaled $1 million. So there's $1 million of gain, the difference between what they bought the investments for and what those investments are worth today. And so big if here, if John and Jane sell those assets during their lifetime, they're going to incur capital gains tax on that appreciation since they originally purchased those assets. And here's where the step up in basis really kicks in. If they don't sell those assets, and maybe there's a reason they should sell some for investment purposes, maybe we'll talk about that. But if they don't, then because you don't want to do everything for tax purposes, but if they don't sell those assets and they pass away and those assets that they originally bought for $1 million are now worth $2 million, all of that $1 million of appreciation will go completely untaxed. Because when their children inherit that stock, then and that stock was included, because that stock was included in the estate of John and Jane for federal estate tax purposes, even though there's no estate tax due, it's in their estate. But we have this $13 million exemption that shields it from estate tax. Because that stock was in John and Jane's estate, it gets a step up in basis. So now when the kids inherit that $2 million of stock, if they do sell it, and they'll inherit it in their trust accounts that you'll be overseeing, Jacob. If they want to sell those assets immediately after John and Jane die, they can do it without capital gains tax because they sold it immediately after death. After they recognize that step up in basis, all that $1 million of gain went untaxed. And now you'll be in a position to kind of get them a more diversified portfolio based on their investment needs in the future. So that's the step up in basis. What I want to get some feedback from you, Jacob, is, if they do come to you and say, I have this wide array of investments in our brokerage account that's basis of $1 million and $2 million, we're 65, we don't know how long we'll live. but I have this IRA, and maybe they tell you, I understand, I can, buy and sell and buy and sell, and that doesn't trigger any kind of capital gains tax.
Mm-hmm.
What would your philosophy be on investing for those couples who would like to minimize the overall tax effect during their lifetime and when they pass away of investing in the brokerage account versus investing in the IRA?
Yeah, wonderful question. So what this lends itself to is what's called asset location. And so we want to invest each of these different account types simply because of how they're taxed. We want to invest them differently. So we want the brokerage account to be the one that grows the most. If step up in basis is kind of part of our goal for the future, we want that one to grow as much as possible so that the kids can receive as much as possible tax-free. Also, to a brokerage account or a trust account for that matter, it's taxed every year. So if you have dividends or interest that come into it, it will be taxed every single year at whatever tax rate is applicable. So we kind of want to minimize that if we can. We want to suppress that a little bit. So we wouldn't want to have all money market on that $2 million, right? Because then we're getting, or at current rates, 5% on that $2 million. We're going to pay normal income tax rates on that interest that we're getting. So we probably want to get even like some people, hey, dividend stocks, those are great, right? Well, maybe not in a brokerage account because of the fact that those dividends will be qualified, yes, but you will have more dividends that you're going to have to pay taxes on if you have, let's say, just an average portfolio of lesser dividends coming in. So that's on the brokerage account side. Now, we want to pair that with the traditional IRAs, and we probably have the traditional IRAs invested less aggressively. And the reason for that is a couple things. Number one is to help get the overall allocation for the portfolio correct. So if they wanted to have, let's say, a 70-30 portfolio, stock to bond or stock to bond to cash, we'd probably invest all of that bond and cash or fixed income type assets in the traditional IRA, because every dollar that comes out of traditional IRA is going to be taxed as normal income no matter what. And if the interest or dividends that's coming off of those particular investments is going to be taxed as normal income, we want to have those be sheltered in that account as well. Also, too, traditional IRAs, you are only going to pay income tax in the years in which you actually have income distributed from the account, not whenever it's actually earned. So that's another factor as well. Now, on that $2 million traditional IRA, we want to, in some ways, control or curb that growth, because there's another factor at play here from a tax standpoint, as opposed to just annual taxes. It's RMDs. So they're 65 now. At 73 or 75, they're going to have to start taking money from this account, whether they want to or not, or whether they need to or not. So required minimum distributions, that's what RMD stands for. They will be forced to distribute assets out. That's whenever they will have to begin paying taxes if there's money in the accounts. So if you think about it, if they invest their $2 million over the next 10 years super aggressively and they get it to $5 million, well, now they've just built up essentially a larger tax bill for themselves once those RMDs kick in. So we'd want to grow the brokerage account more and almost suppress the growth in the traditional IRA so that we are using the account types and the taxation of each to our advantage, both now, but also like we were talking about with the estate part of it, but also for the future. So maybe that answers your question. Asset location is the term that we're talking about there. And it's something that definitely should be paid attention to. It's one of the easiest ways to save thousands of dollars potentially every single year on taxes.
Yeah. And I guess once they start taking those RMDs in 10 years or whenever it is, they have these $2 million accounts. And so they take some RMDs out of this IRA, and they don't really need those RMDs to live off of. So that gives you some additional assets in the brokerage account, which you probably have more flexibility from an investment standpoint, because you're not so worried about the step up in basis, because you'll be starting with a clean slate with those RMD assets that get moved into the brokerage account. So that's kind of the way I see it.
Yep. Yeah. So lots to navigate there. That's the fun part of the planning process for me with different clients. So on your end, here's a question for you. Back to this, if we were to leave traditional IRAs to the kids rather than a brokerage account, what's the problem with that? Is there one?
Yeah. From an estate planning perspective, and let's talk about the problem child, because that's the issue here. Let's say you have a child, you don't want to dump money into their lap. You'd like it doled out over time to them. So it matters, and your options vary depending upon whether you're leaving a child like that assets from a brokerage account or bank account, I'll lump those into one, a Roth IRA or a traditional IRA. So brokerage account, cash, lots of flexibility there. You can leave that to a trust. Of course, it gets the step up in basis when you pass away. You can designate a trustee, and an inheritance from a brokerage account or a bank account. It's income tax free. So you're not dealing with many tax issues when you leave money from a brokerage account or a bank account to a trust for a beneficiary, and you want that money doled out over time. Similar, little more involvement when you leave a Roth IRA to I'm just going to call it problem child. I hate to say that, but I'm being blunt. In trust for a problem child. You still have these 10-year RMD rule, but if you have a problem child, you really want, after John and Jane pass away, you really want that Roth IRA money, all of it, to just keep growing for that next 10 years. And all of that growth is income tax-free, capital gains tax-free. It's amazing. Right. So often with a Roth IRA, when you have a problem child, you got to set up that trust so that those distributions from the inherited Roth IRA don't even start until 10 years after John and Jane pass away. Completely different scenario when you're leaving the problem child. I'll call him Paul. That's my name. When you leave Paul a traditional IRA, because now we could talk for hours on it, but if sounds like John and Jane are the type of people who would like to try to minimize the overall tax burden. And so then all that income tax on Paul's $600,000, $700,000 amount from the traditional IRA, all that income tax, those assets have to be distributed to Paul, and income tax has to be paid within 10 years after John and Jane die. Now, maybe if Paul's a real problem child and he really blows money, maybe you give a trustee discretion to make distributions from that inherited traditional IRA over a 10-year period. Maybe you set it up in a trust so problem child Paul gets equal distributions over the 10-year period. So we've worked with a lot of people with the traditional IRA for those people who don't want a child or other heir to get it in a lump sum. There's a discussion about, okay, how do we want the traditional IRA payable so that we meet the RMD requirement, the Secure Act of making it all payable to them over 10 years. And then perhaps after the 10 years is up, then they get distributions from the Roth IRA and the brokerage account. So a lot there, lots to discuss, but that's what's going on in my mind.
Yeah, and whether in regardless of, and correct me if I'm wrong here, but regardless of whether an individual is named as a beneficiary of a traditional IRA or a trust, that 10-year rule still applies. And so what happens after it goes into the trust and whether it's going through or if it stays in, that's all dependent on the trust, correct?
Yeah, it all gets distributed. It can be, it's typically distributed to what I'll call a see-through trust, which meets these IRS regulations, but it's often what's called a conduit trust. So still the money has to come out 10 years, but then either if it's what I call an accumulation trust, the trust pays income tax at higher trust income tax rates. But if it's a conduit trust, then the trust receives the distribution within the 10 years, and then the trustee immediately disperses that to the beneficiary. So the beneficiary, problem child Paul, can pay income tax at Paul's lower income tax rate than the trust income tax rate. So there's a lot of confusion there, and a lot of this is new because the Secure Act just passed 3 or 4 years ago, and people are still trying to figure it out. So I will say, maybe I won't say this in a few years once everybody's figured it out, but we use trusts as beneficiaries of IRAs. I call it only when we have to. Yeah. If you can name individuals as beneficiaries, people understand the rules easier. When you name trusts as beneficiaries, you usually have several people involved in that distribution to the trust from the traditional IRA. You've got the beneficiaries of the trust, the trustees, the financial institutions, the financial advisor, the lawyers. And usually not everybody's on the same page and it gets confusing. So again, those are all factors we have to take into account when we're setting things up the right way.
Yeah. And a lot of it goes back to the fact that retirement accounts are not probate assets. just like a house or a brokerage or trust, like all those could be, or I guess not a trust, but they could all be probate assets. And so if you've got a will that says, hey, I want it to go to Bob, and your IRA says I want it to go to Sue, it's going to Sue. So Bob is left out regardless of what your will says, because of who's named on the account as the beneficiary.
Well, that just leads into, I'm not going to get off this live stream until we have a discussion about how the financial advisor and the lawyers can work together for a result that doesn't have unintended consequences. Because if Jacob and I aren't talking, and Jacob has no idea what the client is doing from an estate planning perspective with their will and the trust, and I have no idea how Jacob and his client have set up beneficiary designations, there's a chance things get mixed. But when there's that collaboration, it significantly the opportunity that mistakes will happen.
Yeah. And back to the point of, where for retirement income purposes, knowing all this, having these conversations with the client involved, between you, I, and the client, hypothetical situation, if we're all talking together and we're like, hey, part of the goal is to live now and enjoy life. We need some income from our portfolio, but we also want to leave something to our kids and grandkids one day. What are the best assets to leave, right? And that will help dictate where we pull money from in retirement while they're alive. So that's the importance of it, because they have to work together. They have to play together, or else I'm taking all the money from the brokerage account every year at a 0% capital gain rate, and they're spending that money. But what happens is now their IRAs are growing in value over time because we're not spending those assets down. So the brokerage accounts are going down in value, even though we're not paying much in tax. You're going to build a bigger tax bill for the kids and grandkids because you're not distributing those IRA assets. So all of that, I guess, is a good reason to work together and make sure that everybody's on the same page and that nothing is being offset by one another.
Yeah. And really on that note, and look, I don't know who's watching. If you're in a certain profession, feel free to throw it in the chat. I know there's a lot of just really kind of smart people watching that are looking for some education and maybe a little bit of entertainment. Not going to get too much entertainment from me, but you may get some education from me and Jacob. There might be some financial advisors out there who are just constantly looking for tips to how can we improve things? How can we deliver better service? Might be attorneys out there watching us. So what I'd like to share is just, how can it work? Not that my process is the greatest process ever known to man or ever known to estate planning, but I'd like to put some things up on the screen and show you kind of how it looks like when an attorney like myself and an advisor like Jacob kind of work together. So John and Jane, maybe they went to Jacob first and maybe saw some of Jacob's videos. They're fantastic. I suggest you watch them. And got in touch with Jacob and said, look, Jacob, we're kind of interested in talking to you. And they reveal all these things to Jacob. And part of what they reveal is, Jacob, we don't have our estate in order. We have these issues with certain children of ours. One child's been divorced, et cetera. We want to avoid tax. Can you help us? And Jacob says, of course, I can guide you through that. So it just so happens, kind of now let me go through how it would work. So it would work with kind of Jacob having my calendar right there that he can pull up a link, because now we got to coordinate schedules of the estate attorney and Jacob and the clients. And so Jacob having a link to the calendar really is nice, but it starts by setting up that meeting, and maybe you set something up for, June 5th or whatever, but so you'd set that up. And then from there, I know Jacob's office has some client portal information. We have it too as estate attorneys, but we give this to all of our clients. And I suspect that John and Jane would make Jacob an assigned user of their estate portal right here. And this is where John and Jane can really help themselves out, help me out by documenting family and asset information. In addition, once all their estate planning documents get signed, which we'll talk about in a minute, then all these documents can be uploaded to John and Jane's portal, and that way we have access to them. Jacob has access to them. John and Jane's children, if John and Jane took advantage of the opportunity to maybe name one or more of their children as users on their portal, they'd have access to documents. But really the way it starts is once that Zoom meeting is scheduled, we'd have maybe get back. I'll come back to the screen later, Jacob, but we'd schedule that Zoom meeting. Jacob would be on it. I would be on it. The John and Jane would be on it. And usually what happens, if we're there to talk about the estate issues, it's my role to lead that discussion.
Yeah.
But Jacob has had a number of discussions with John and Jane. So Jacob knows John and Jane better than I know John and Jane. This is the first time I've talked to them. So I'll lead them through the discussion, and I'm sure we talk about how they want to leave things to each other. Do they want to leave things outright to the surviving spouse? Do they want to leave things in trust so that the children have a little more protection? What are the capital gains tax consequences of that? How they want to leave things to the children? That concern about the child being divorced, the concern about the child handling money. Do they want to treat all of their children the same, or are they okay with designating that the portion for the irresponsible child is going to be handled a little differently? We'll navigate all of that tactfully. I suspect, Jacob may chime in during that meeting and say, well, Paul, I've been talking to John and Jane for a few weeks now, and one of the things they told me was maybe something that didn't come out because I didn't ask the right question, or maybe John and Jane didn't think to volunteer some information. So having Jacob a part of that estate planning discussion, really, really valuable. We're able to turn over every stone that we need to overturn. And so we have that discussion. We summarize kind of what's the easiest way to accomplish what John and Jane are trying to accomplish from an estate planning perspective. And then then we get to work preparing things. And then so we'll go through a process of preparing all of the estate legal documents, customizing them the way John and Jane wanted. Then we'll hop back on a video call, and this is what we call our review meeting. And I'm sure a lot of lawyers do this, but this is where we kind of pop up the John and Jane Doe Trust. And so this is where, we'll highlight things and say, well, John and Jane, this is where we said that when one of you passed away, things would stay in trust for the surviving spouse. We say that after you both pass away, then each child will have their own inheritance trust. And we'll point out all those particular provisions, who's going to be the trustee to handle all of this when they pass away. And so what are all those trustee powers and other provisions we need to put in the trust? We'll show them their last will and testament. And because John and Jane did have a revocable living trust to avoid probate, they'll have a pour over will. We'll talk to them about how their will basically provides that if they have any assets in their name that do need to go through probate when they pass away, the goal is never have to use this will, but occasionally people have assets that have to go through probate when they pass away, for reasons we can talk about later. But this is what's called that pour over will, just leaves whatever, and this is John's will, leaves his assets to his trust so that trustee can then distribute them in accordance with the provisions of the trust. Every time we create an estate plan, this is, for example, a set of Texas documents. We have a national boutique estate planning law firms. We're able to help clients around the country. Texas has what we call a statutory durable power of attorney. So we would walk them through that and walk them through the decisions that they've made and that they'll document on their Texas power of attorney. We'll show them the customized. Here's where John appointed Jane as his agent for medical decisions that may need to be made in the future if John's not able to make his own medical decisions. And so, and then there's the living will, which is the statement about life support machines. One other unique piece of our process, we'd have Jacob and the client join what we call our impactful inheritance community. This is a great place. We're adding content all of the time. Our clients are invited to be on it. And it's a great place where there's just, we add a lot of resources. People can talk with other like-minded people about their estate planning goals and how they meet those goals. There's events that we have. I'm conducting events really on a weekly basis for our impactful inheritance community members. So while we have on a YouTube, we have people contributing to a chat, this takes that community piece to another level. So Jacob, you can go back to the regular screen. So yeah, that's the process, getting people like Jacob involved from the get-go. And one thing I like about it, because when Jacob has a client and he refers a client to an attorney, kind of turns them loose to that attorney, whether it was me or somebody else, Jacob doesn't really know the level of service that his client is getting. Jacob's working hard to make sure his clients get great service, and he wants his client, John and Jane, to get that same level of service from the estate planning attorney. And if that attorney provides a poor level of service, it turns out to be a poor reflection on Jacob. So what I like about the advisor being involved is the advisor is seeing with their own eyes and ears everything that the client is going through. They're in all of the meetings, they're participating. It creates more client engagement for Jacob, creates more, loyalty that the client will have to Jacob. As part of the process, Jacob may get an opportunity to meet John and Jane's children, or at least some of the children who may be involved later, which helps with that kind of intergenerational transfer of assets. So my kind of plug for this is you advisors, you attorneys out there, kind of figure out a way where you can work together, all for the benefit of the client. And really it's a win-win-win for everybody. So wanted to share that this afternoon.
Yeah, for sure. Well, that's awesome. I love the community part of that. That's pretty neat. That's really cool. I'm sure a ton of value. Yeah, a ton of value for those who are a part of it. So someone goes through your process. Let's say I'm in the meetings and everything like that. Now the next step is, okay, we've got the trust created. We've got wills established. We're done, right? No, we're not. We've actually got to change stuff on the accounts. Perhaps we need to make the trust funded and actually get that something there in the trust. We need to rename a beneficiary perhaps, or we need to rename things on the account so that we actually don't offset everything we just did again. So that's another reason to have the advisor in the room and in the conversations, because sometimes what happens is, hey, Mr. Miss Client, we need to get a trust established because of kind of what you described me. So we need to get you in touch with so-and-so. That happens. I check back in a month or two. Hey, did you ever get that done? Yes, we got it done. We're taken care of. Thanks, Jacob. So, oh, well, we probably need to make some adjustments here, don't we? So no, they made the trust. We're good to go. It's like, well, we need to make some adjustments so that actually works the way you thought it was going to. So that's another part of it, is it has to come back to the advisor a lot of times, or back to the accounts, to make sure that what you're trying to do actually ends up happening.
Yeah, that's not only the beauty, but the necessity of the advisor playing a role in the estate planning process. If Jacob's in on those discussions and he's in the room, he knows exactly what it needs to do. And maybe even after the client leaves the Zoom meeting, maybe Paul and Jacob get together and say, all right, let's make sure we each know what we're responsible for to make sure this client and his family is served as well as they can be. So I might say, Jacob, let's have a conversation, or Jacob may say, Paul, how do these accounts need to be titled? How do we need to designate the beneficiary on the IRA? You've got a child of John and Jane's. They don't want that child getting 1/3 of the IRA in a lump sum. So we'll have a conversation about, well, we'll need to name this child's trust as the beneficiary of their IRA or whatever it may be. So
for sure,
it's not only, does it make sense from a client, by the way, I showed you a statistic, Jacob, once, and it's just so true. Love to hear your comments on it. I think eMoney did some type of poll or did a research study, and they realized that 93% of financial advisors' clients want their financial advisor to guide them through the estate planning process, but only 22% of financial advisors even get involved in their clients' estate planning. So I do feel like the financial services industry, they have a tremendous opportunity. I think they're trying to figure out how to take advantage of the opportunity. They're balancing this. Well, the financial services industry is saying, well, we're not lawyers. We can't draft documents. We can't commit unauthorized practice of law. So I really feel like that perfect solution is when the advisor and the attorneys collaborate, because that estate planning piece is such an important piece of the overall kind of wealth management piece. And so I'm looking for, over the next couple of decades, financial services companies, kind of, you're taking the lead, Jacob, by kind of initiating these discussions here, and I applaud you for it. But I really see that in the future, as a way where financial services companies can differentiate themselves.
Yeah, and those stats definitely sound about right. They definitely sound about right. In fact, that 90+% of people that I talk to are, hey Jacob, what should I do with my estate plan? Like, or do you even review these things? And the answer is yes, I can review them, and make sense of them, right? But I'm not an attorney, so I probably want to pawn that off to someone like Paul and say, hey, this may be above my head. I didn't learn this stuff. This is not my field that I kind of operate in, but I know enough to be dangerous. So that's where it's like the partnership, building that together, I think is huge because the client gets what they need and want. But also too, a lot of times, I think estate planning is misunderstood. I've heard many times, hey Jacob, I don't want an estate plan. It's like, well, you don't really get a choice in that. Like if you're going to pass away one day, like something's going to happen with your money and your assets. And so at least let's plan for what that will be rather than just not have a plan. So either it's a good plan or a bad plan, but you have one. And so I think that that's a big deal. And for us putting it together, how do we make sure we work together so that the client gets what they need? I think our industry is making steps towards that. But again, it's hard I can't practice law. I can't give legal advice. So who do I help with that conversation? So someone like Paul would be a great fit. But Paul, I don't know, you have any questions coming through on your end?
I've got my usuals. Want to shout out to Ann. Can drawing too much out of 401k can interfere with Medicare? So I think.
What was the question there again?
Can drawing too much out of 401k that interfere with Medicare?
Absolutely. Yeah, it absolutely can. This is what's called IRMA, or income related monthly adjustment amounts. And it has to do with your Part B, but also your Part D premiums on Medicare. I don't have the amounts memorized for what it is this year. The key is if you make too much money in terms of taxable income, AGI, you could be paying an increased premium on your Medicare premiums for at least 1 year. It's not forever, but it's a 1 year at a time, and it's always looking back to 2 tax years ago. So for example, if I earned above that limit this year, I would not pay my increased Medicare premiums until 2026. So it's always 2 years. It's looking 2 years in the past, and it's only for that 1 tax year that I would pay an increased premium. So whatever my income is in 2025, that will dictate what I pay on my premiums if I need to pay more in 2027, and kind of so forth. So again, Paul, this plays into what we're talking about here with the $2 million IRA and RMDs in the future. Those RMDs, if they're too large, they could push you over that IRMA income cliff. And so the key there is it's a cliff. As soon as you have, let's just say the cliff is $150,000 and you make $150,000, $50,001, you went over the cliff. Therefore, you go to that next level of the bracket. It's not progressive like our normal tax system is. So yes, the answer is yes, you can make too much money from a tax standpoint, which would make your Medicare premiums more expensive.
Yep. Great. Thanks for that, Jacob. I see a new name, and maybe you'll understand this question. It says how to search criteria for states that tax lump sum retirement withdrawals. I don't really know what they're getting at.
It depends. I know there are some states that do not tax IRA distributions. There are a few. I don't know if that fits into what you're asking there, but it could be if you're distributing from a 401k or an IRA. It could be taxable or it could not be. Depends on the state you're in. So that's maybe a question for the Google machine.
Oh, by the way, Ann said thanks for your answer to the previous question. Yep. All right. I could ask you this question outside of our viewers' presence, but let me just ask you. I know you've been in the field for a while. You've started your business, and you're getting a lot of traction. You're getting clients from around the country. Tell me and our viewers kind of like where are those investments held, and kind of what's the process for working with Jacob? Yeah.
So a little, I guess, a background. So as an advisor, you can work for a Morgan Stanley, a Merrill Lynch, all these different places, which are wonderful companies. Or you could be an independent advisor, meaning you get to kind of select how you want to operate in different ways like that. So I'm an independent advisor, what's called a registered investment advisor, RIA for short. And so for us, we don't want to custody your money in the back room here at the office. We want your money to be with a reputable custodian. So Charles Schwab is the custodian that I use for all my client accounts. So technically what we really are doing is, John and Jane, they have their accounts. They're going to open those at Charles Schwab. They're going to have their brokerage accounts and their IRAs. And then I'm just a limited power of attorney to be able to see into their accounts and also manage the investments. I cannot change their beneficiaries without their signature. I can't update their addresses without their signatures or anything like that. All I can do is I'm a glorified middleman in many ways, but I get to see into everything. And so their money is always at Charles Schwab, or it could be Fidelity, for example, as well. And the key there is if something happens to me, a risk on their end is like, what happens to our money if Jacob gets hit by a bus? It's like, well, your money's still at Schwab. I'm not here, so I'm not the advisor anymore, but it's still protected and safe at Charles Schwab. So it's really as simple as that. If somebody wants to become a client, we take wherever all their money is in different places. Typically, you got an IRA here, a 401k there, an old 401k there. And so we want to consolidate all that, simplify it down into a few accounts so that we know what's going on. And that really makes the estate planning part probably a lot easier as well. That way we can make the best decisions and keep it really simple. I'm a fan of simplicity. And so if we can eliminate confusion, that's wonderful. And your accounts will be transferred and consolidated there at Charles Schwab, and I would be the advisor on it. And that's pretty much it. Yeah,
well, I'm glad I'm not the only one that gets the what if you get hit by a bus question.
Yeah.
So it's funny that people ask you that. But yeah, same thing here from our perspective. If we help them, they have their portfolio, with estate planning, it's still wet signatures on paper documents. So they have all that. They have the electronic version. I don't need to be there when they pass away for things to go smoothly. So our job is to set things up so things can go smoothly, but we don't need to be there. So yeah, life will go on if either one of us gets hit by the bus, but let's hope we don't. So
yeah, I think folks like you, Paul, y'all are huge in the attorneys anyway. You're huge in the setup of those estate plans. A lot of times, the advisor, having that relationship with an advisor, can help handhold and guide through the actual, hey, who gets what, when is that being distributed, or Jacob, I inherited an IRA from my mom. What do I do? It's like, well, do we open? We probably need to open an inherited IRA for you, have your portion distribute over into your new inherited IRA so that we can begin that distribution process. All those different things, the advisor and having that relationship built in up front helps whoever is after you. If you get hit by a bus, or if you're receiving money from someone, what do you do when you get it? That's, I think, a huge deal, as opposed to having to navigate, hey, who do I talk to and how do I trust someone whenever I'm going through this emotional hardship, right? And I've got to figure out all this money stuff at the same time without any trusted counsel. So it's I think, important to have all those established, beforehand if possible. Yep. Super.
So yeah, we got a lot of thanks and good evenings and all that. So
awesome.
I think we're questioned out. And so any last thoughts from your end, Jacob?
Nope. This was fun. Why don't we do it again in 2 weeks? How about that?
That sounds great. Yeah. 2 weeks from now. So you guys can put it on your calendar. Look forward to chatting again. All good stuff.
Awesome. Thanks, Paul.
Thanks, Jacob. We'll see you.
All right. Bye.
Bye.